Welcome to EUPrivacyForAll Session45 on GDPR, Competence of the Supervisory Authority, Main Establishment and Lead DPA. In negotiations regarding the competence of the Supervisory Authority, both Article 51 and 51A should be paid attention to. European Parliament modified the initial Article 51 in order to state that each supervisory authority shall be competent to perform the duties and to exercise the powers conferred by the regulation on the territory of its own member state. On its side, beyond modifications of Article 51, EU Council added Article 51A in order to specify how each supervisory authority would be competent and interact with others on the basis of the notion of main establishment. Article 51 in GDPR sets that each supervisory authority shall be competent to perform the tasks and exercise the powers conferred by the GDPR on the territory of its own member state. As suggested in EU Council draft, it also specifies that the processing carried out by public authorities or private bodies acting on the basis of legal obligation or of public interest would entail that the supervisory authority of the member state concerned shall be competent. In such a case, competence articulated as in Article 51A will not apply. Finally, supervisory authorities shall not be competent to supervise processing operations of courts acting in their judicial capacity. The key provision regarding the competence of supervisory authorities is based on Article 51A regarding the competence of the lead supervisory authority. It is based on the definition of the main establishment. The supervisory authority of the main establishment of the controller or the processor shall be competent to act as lead supervisory authority. By derogation, each supervisory authority shall be competent to deal with a complaint lodged with it or deal with a possible infringement that relates only to an establishment in its member state or substantially affects data subject only in its member state. Moreover, the supervisory authority shall inform the lead supervisory authority without delay. Within a period of 3 weeks, after being informed, the lead supervisory authority will decide whether or not it will deal with the case. Where the lead supervisory authority decides to deal with the case, the supervisory authority which informed the lead may submit to the lead a draft for decision. The lead shall take utmost account of that draft. In case the lead would decide not to deal with the case, the supervisory authority which informed the lead supervisory authority shall deal with the case. Finally, the lead shall be the sole interlocutor of the controller or the processor for the cross-border processing of that controller or processor. This is key regarding data transfers. A key recital in GDPR to define the lead supervisory authority is recital 27, as it defines what is the main establishment of a controller, of a processor, or of a company being both controller and processor. The main establishment of a controller is the place of its central administration, unless decisions on the purposes and means of processing are taken in another establishment. Objective criteria will apply regarding the real exercise of management activities. The criterion should not depend on where the processing of personal data is actually carried out. Regarding the main establishment of the processor, it will be the one place of its central administration, and if the processor has no central administration in the Union, the place where the main processing activities take place. In cases involving both controller and processor, the competent lead supervisory authority will be the supervisory authority of the member state where the controller has its main establishment. The supervisory authority of the processor, in such a case, should be considered as the supervisory authority concerned that will participate to the cooperation procedure. Finally, where the processing is carried out by a group of undertakings, the main establishment of the controlling undertaking should be considered as the main establishment of the group of undertakings, except where the purposes and means of the processing are determined by another undertaking. Recital 97 reminds the same principle as set in Article 51A and Recital 27. Whenever a processing substantially affects or is likely to substantially affect data subjects in more than one member state, the supervisory authority for the main establishment of the controller or the processor should act as lead DPA. EDPB is supposed to release guidelines on the criteria to be used to ascertain whether the processing in question substantially affects data subjects in more than one member state. In Article 413, defining what is the main establishment for the controller and the processor, it is stressed that the main establishment of a controller would be the place of its central administration, unless decisions are taken in another establishment and this establishment has the power to have such decisions implemented. For a processor, the main establishment will be the place of its central administration in the Union, and if the processor has no central administration in EU, the establishment where the main processing activities take place. Currently, the directive stresses that each DPA acts with complete independence. It also stresses that each supervisory authority shall hear claims, and each supervisory authority is competent, whatever the national law applicable to the processing in question, to exercise on the territory of its own member states the powers conferred by the directive. Each authority may be requested to exercise its powers by an authority of another member state. What should accountable data controllers and processors get prepared for? First, they will have to identify their main establishment in EU in order to determine the lead supervisory authority. For the controller, the main establishment would be, on the principle, the place of its central administration. By exception, the establishment taking decisions on the purposes and means of the processing, if having the power to implement it, will be defined as the main establishment. Caveat to stress is the fact that the qualification of the main establishment of a controller does not depend in any way on the location of the processing or of technical means used. Regarding the processor, the general rule is that the place of the central administration would determine the main establishment. As an exception, if the processor has no central administration in EU, the establishment where the main processing activities are will be defining the place of the main establishment. In case both controller and processors are involved, the main establishment of the controller will be the one defining the lead supervisory authority. The main establishment of the processor would determine a supervisory authority to be concerned and being part of the cooperation procedure. Regarding competence beyond the definition of the main establishment and of the leading supervisory authority, several derogations can be outlined. First, in case of an infringement or a complaint related only to an establishment in its member state, or of substantially affecting data subjects only in its member state will entail that the supervisory authority of this member state is competent. As framed in Article 51A, the lead DPA will then have 3 weeks to decide to deal with the case and take the utmost account of the draft proposed by the concerned DPA, or not to deal with the case. A second derogation regarding competence lays in the processing held on the basis of legal obligation or of public interest. In such a case, the supervisory authority of the member state defining such a legal obligation or public interest would be defined as competent. The last derogation regards the fact that the lead supervisory authority will be the sole interlocutor of the controller or processor for its cross-border processing, that is to say, for data transfers framing. The key question raised now is knowing whether a consistent application of the lead concerned DPA will be feasible and how it will be concretely framed.